Okay, let's push record, record, record. We are live and 3, 2, 1. We are live with our own Martin Galea from Tickbox Conveyancing. Martin, how are you?
Yeah, very good, Jazz. How you going? How's your day been?
Pretty well, thank you.
That's good.
Pretty busy, which is good. Always fun being busy. Just doing a lot of networking today. As you know, Wednesday I was actually at one of the Point Cooks BNI and doing one-on-ones, and then back to the client meetings and Zoom calls, talking to buyers, virtual inspections, and here we are with yourself.
And all of a sudden, it's this time of the day, and you look back and think it went really quick.
Exactly.
Mm.
I was looking at my diary. Still got a few things to tick off before we finish off today, I guess, after we finish off with our live today.
So you're looking to tick a few more boxes today, are you, Jazz?
Yeah, there's a fair bit of stuff need to be done. Some reports need to be sent out, which is fun. Yeah. I mean, a lot of things are happening at the moment. Look, a lot of people are asking about what's happening. We're sending out a lot of appraisals and reports out to the sellers or potential sellers who are ready to come on the market now or sometime in the next couple of weeks or couple of months when things open up, and we hear more from Mr. Dan Andrews.
Yes, we're all waiting with bated breath, aren't we, to see whether we'll get some relief earlier rather than later. But he seems pretty steadfast to stick to the roadmap, as he's called it.
Absolutely. I guess the things are pretty steady from our perspective. We're still able to sell and secure buyers for our clients without any questions. Things are working differently than before, even compared to last lockdown. Things are happening. Things are happening with a difference or unusual times and unusual activities happening around, which is fine if you just sort of adapt yourself and if you have the right mindset. And if you say, okay, well, let's change the gears with the changed times and let's go up to the speed.
Yep. I suppose it's a bit like that with us. Thankfully, we as a conveyancing practice, we sit back in our chairs with our screens in front of us and steadily settling matters. So, the PEXA platform, settlement platform that we use, which is all electronic, has certainly enabled us to settle during these difficult times without too many issues, I should say. And contrary to, I suppose, what a lot of other people think, that the banks have been very cooperative in getting matters settled on time. Sometimes they'll leave things to the last minute, but yeah, we're getting matters settled consistently on time without too much of a hassle. We're preparing our clients well to be aware of, on the day of settlement, that setting a time for settlement in itself isn't concrete till the day.
Right.
We are getting matters settled, and we're getting a lot of inquiry to do pre-purchase reviews. So we've got clients that are really interested in looking at property, even though they haven't actually seen the property physically. They've had virtual tours, and we're surprised at the amount of people that are rather satisfied with those virtual tours and wanting us to review contracts and provide them with reports.
Wow.
And we're getting many vendors now starting to prepare for the marketing of their properties. So they're giving us lots of time to prepare contracts and Section 32s for them so that they can launch and support the marketing campaign. So that as soon as there's buyers that are interested, they've got documents to show.
Absolutely. And I guess it's certainly time where people are getting ready for and hoping that things will open up by the end of this month or early next month, or 26th of or 23rd of October, as proposed by the government. But I guess with the numbers coming down, it's certainly expected something would happen. REAV is trying to lobby the meetings with the cabinet as well to see if we can get things up to speed, or there's some petitions being signed as well. But before we go ahead, Martin, I would love to introduce yourself and people who know you. And I know a lot of people. You are a well-known person in the community of real estate and in conveyancing world. People who don't know yourselves, I've got Martin Galea from Tickbox Conveyancing with a network of conveyancing offices from Mornington all the way to CBD and Moonee Ponds. Martin, can you tell us a little bit about yourself for the community or people who are watching us today, and a little bit about what you do amazingly? And I know, and I love your work, and I know our clients always say thank you that Martin and his team have looked after our transaction.
Sure. So my journey in the conveyancing space started, believe it or not, back in 1984. So I started as a law clerk and studied at RMIT during that time.
Right.
And then over time, set up one of the very first conveyancing, non-lawyer conveyancing practices, if you like, and slowly have, progressed to have this practice now, Tickbox Conveyancing, which is made up of 14 staff members, team members, if you like. And as you said, we're spread out over the three locations of Moonee Ponds and CBD, at the corner of Queen and Franklin Street. And then we've also got an office on the beautiful Mornington Peninsula.
My dream place.
Yeah, so there's a lot of synergies around having all the offices and being able to float myself between the offices, because we obviously have clients that live locally here, for example, in Moonee Ponds, northwestern suburbs, that have got property on the peninsula, and they see an advantage to have us involved in perhaps selling their properties locally in the northwestern suburbs, and then making a sea change and knowing that we're local there too. So that's been really good and exciting. The team, we've got a team of a lot of qualified licensed conveyancers and the like, and lots of support in the team. So we've progressed quite nicely. And during this pandemic and so-called lockdowns, we've been fortunate that we've still had a steady stream of work coming through. We just sort of keep our feet on the ground and try and make sure we provide really good service and just be really well known for giving good quality advice and being very reliable, making sure that we're available. And conveyancing is not a 9-to-5 job. I'm sure some of my colleagues and competitors will probably say that, they wish it was just 9 to 5 and Monday to Friday. But we just a bit like you guys, we need to be available to provide the services that people are looking for when they become extremely anxious about buying or their property's about to sell, and they want to know they've got that support.
Absolutely. Do you love Saturdays when 3 o'clock or 4 o'clock you get a phone call from an agent after an auction?
Yeah, you talk about calls on Saturdays. Sometimes I'll get calls 10 o'clock in the morning from agents that are looking. They've got an auction that's being held. Somebody's thrown a curveball at them from prospective buyers. Not sure how to answer it, and they're looking for some assistance. And may not be a matter that I'm actually involved in, but it's not the first time I get a call from an agent, asking for my opinion on how to handle certain queries and or situations. Then you'll get scenarios where an agent, for example, has just sold let's say there's a block of 12 units, they've sold unit 2, and the neighbour that owns unit 3 sees that there's a disappointed underbidder, and will throw a curveball at the agent and say, do you reckon the underbidder's interested in buying my property? Then all of a sudden we've got to swing into action and get some documents prepared rather quickly, so that deal can be done. And that's obviously a service that we provide and provides a great opportunity for agents and vendors and buyers alike. So again, if we act for a vendor and we do a really good job at getting documents together, that doesn't just benefit the vendor, even though that's our client, but it also just creates opportunity for the buyer to make a purchase. And, if there's a buyer's advocate, they get an opportunity to assist their client with a purchase, and, having quick, swift action, all the momentum happening at that same time.
Right.
It's everyone to make their decision clearly and move on and do the deals.
Right. It makes a huge sense. Sometimes it's about timing as well. Timing is critical about preparing the paperwork and before the buyer goes cold. And I guess from the auctions, what's your advice to the buyers and the other agents as well? Having a personal check and a bank issued check at the time of signing the contract, you need 10%. what are the risks involved? It's out of the topic, but it just came into my mind that a buyer buys a property at auction, says to the agent, "I'll give a 10% check," but property is sold, and the buyer says it's a personal check. What could be the issues with that?
Well, I suppose at the end of the day, if the purchaser provides a check and the vendor accepts that check, or you as the agent accept that check and bank it into your trust account, and the check bounces, well, the purchaser's immediately in breach of contract. And then the vendor will have to pursue their rights to obviously demand payment of the deposit, potentially claim default interest for late payment, and even go to the extent of serving a default notice, and there are costs and fees that flow from that. And then, of course, the other alternative is that if the purchaser tries to avoid making payment, then the vendor also has the option to instruct lawyers to issue proceedings for specific performance, which is quite an involved area where a lawyer would seek to issue a writ at the Supreme Court with a view to getting an order from the court that the purchaser must proceed. But it can become quite complicated. So to go back to the initial point about risk, it's really no different to I've seen it happen before where I've had clients that have had auctions. The auction, there's property's been passed in, somebody waltzes up just as everybody's departing, says, "I'll buy the property," issues a check, and the check bounces, and then the question needs to be, how quickly do you deal with that? Do you, rescind the contract and move on and try and resell and then reserve rights to sue later? There's so many different aspects to it. I suppose ultimately with today's access to electronic transfer of funds,
my
understanding is that most agents would expect that the purchasers would transfer the funds on the spot into the trust account. You'll have mechanisms to be able to see that transfer has occurred and see that the funds are actually in your trust account. And everyone can walk away happy and assured, knowing that the first step, that the purchaser's obligations to pay the deposit have actually been actioned, and everyone can sleep easy.
Wow. Can lead up to a lot of issues, I guess.
Yes, absolutely. So that's when that's the ugly side, if you like, of handling a conveyance. And that's why it's important that that if you appoint a conveyancer to handle the matter, that they've got the ability to read the situation, and again there it's in those circumstances very important that that the client be directed to employ a lawyer, for example, if the need comes for that sort of legal action to occur. As conveyancers, we can serve notices of defaults, and we can certainly claim default interest and rescind contracts. But if you wanted to take the ultimate step of taking legal action, well, then that's a matter for a lawyer to do, and that's when a conveyancer should be smart enough to alert the client of that requirement and need to appoint someone that's really well versed in that area.
I guess the knowledge and the capability of a good and capable conveyancer comes into play. How good your capable conveyancer is, while at the same time how they can actually have you protected before all this happens.
Yeah, sure. Oh, that's right. And a well-prepared contract. And a well-prepared contract should do that. And I would suggest that there's lots of really good conveyancers out there that know what they're doing in that space, and put contracts together that protect their clients.
We've seen so many contracts missing documents, and
Well, that comes back to an issue of the sale documents, as you're aware, are made up of basically two documents. You've got your contract of sale, but you've got your Section 32 statement, or otherwise known as a vendor statement, and that statement is an extremely important document that needs to be put together to ensure that all the information that should be disclosed as prescribed under Section 32 of the Sale of Land Act are adhered to, and now we've also, as part of your your sale obligations, particularly as an agent yourself, as you're aware of the recent changes to the Sale of Land Act to do with material facts. So So there's something that needs to be considered too. But from a conveyancer's perspective, the Section 32 statement is an extremely important document, and
100%.
the client is expecting you to do that properly. And anybody that cuts corners in that area is taking an unnecessary risk just to save a few dollars. The cost of certificates are not that high when you consider what's at stake. And to be honest, the certificates don't take that long to come through. So a lot of the authorities can issue certificates within the first hour of having applied for them. So they shouldn't be, as a conveyancer, you shouldn't be put off, even if you are under some sort of pressure to get documents done quickly, that you don't look to cut corners, that you actually try to cover off on every aspect and of your disclosure obligations, because at the end of the day, the client is expecting you to help them fulfill that.
Absolutely, it makes a huge difference. And Martin, in terms of what we're finding at the moment in the market is there's buyers quite keen to buy, sellers are obviously there. There's less stock available. Buyers have got less choices. This is what I've seen in the market. The trend is the buyers do want to buy. There are people buying sight unseen. We've sold some recently as well with our virtual inspections, and people are depending on the circumstances they're in.
Yeah. No, we're seeing
buying. Yeah,
we're seeing a lot of that, and I'd say that the majority of buyers aren't interested in buying sight unseen, but for those that are prepared to do that, you look at it from the different perspective of a purchaser versus a vendor.
Yes,
and obviously we get the luxury of having the opportunity to work for vendors and also for purchasers. Yes. Obviously not in the same manner. And, if you're looking at it from a purchaser's perspective, it's quite simple that you could make it a term of your offer that the contract's conditional upon the purchaser, in simple terms, having the benefit of being able to pull out of the contract should their inspection of the property, when it's able to be had, doesn't meet their satisfaction. But from a vendor's perspective, if you were going to sell on those terms or accept those terms, there might be an argument that the vendor could also accept that a clause to that effect, but also have another clause that runs concurrently with it that says that, whilst I'm accepting your offer to buy from me, subject to you being able to do a physical inspection to your satisfaction by a nominated date, if you like, or a date so many days after the lockdown is officially over, that the vendor still has the right to continue marketing their property. And if during that period a second purchaser comes along with an unconditional offer, that the first purchaser might be given the opportunity to be notified of that offer being on the table, and being given some time to consider whether they want to waive the benefit of the special condition that they originally were able to negotiate, so that they could still secure the property as first priority or first option. Otherwise, they could elect to withdraw or end the contract based on how the special condition's drawn, and the vendor can then be free to sell to the second buyer on an unconditional basis. And there's risks involved in all that. Your timing's got to be right. There'll be a lot of practitioners out there that might listen to this and think, "Oh, how do you cover for all the different scenarios?" Look, there are ways and means to cover off on a lot of the scenarios, and keep your vendor protected so that they don't lose both buyers, so to speak. Because cooling off provisions, enabling buyers to sign a contract and then cool off, and then you've lost both buyers. So it's a bit of a timing issue in the way that you do that. But for all intents and purposes, when parties are agreeing to sell on the basis of a sight unseen, generally it doesn't get that complicated. It's pretty straightforward. I agree to sell to you, subject to you inspecting the property on a certain date, and once that happens, then it's the purchaser's choice to whether they want to proceed or not. And then the vendor moves on and puts the property back on the market if that doesn't work. So
fair enough. At least they're trying to have an option of securing the buyer. But say, for an example, the buyer puts in a date that right now, I mean, if someone puts a contract in place, if there's a signed contract, to my understanding, which has come through from a lawyer's advice as well, if there's a contract in place during the lockdown and it is subject to the buyers viewing the property before settlement, the inspection can still be carried out under the current circumstances or the under lockdown restrictions as well. But that's another.
I'm not convinced that's necessarily right. I think if the contract was signed before the 5th of August, before the current lockdown, then my understanding is that any services or anything that's consequential to that contract reaching its pinnacle, if you like, inspections can be done. So if you're a building inspector, for example, you can do a building inspection for a contract that was signed prior to the 5th of August. I'm not so sure that an inspection for a contract after that can be done. I've heard some different interpretations along the way. I'm rather conservative, so certainly would be taking the risk. But
we've heard some agents doing inspections under circumstantial loopholes. I guess, say for an example, a buyer signs a contract saying that they will be attending the property on such and such date. Now, if the purchaser does not attend on that day for some reason, and does that mean that they've actually fulfilled that condition?
It'll all come back to how the special condition's drawn, Jazz. If the condition's quite open and in the sense that it's just conditional upon an inspection being done to the satisfaction of the purchaser, and the condition doesn't oblige the purchaser to actually have to do the inspection to deem the inspection unsatisfactory, then there might be an argument that they can pull out. It really comes back to the actual wording in the special condition and how specific it is as to what the obligations are for each party to fulfill their obligations under it. So you can talk in general terms and I can sort of sit there and say, yes, you're right, but it really comes back to the wording, and that's why it's important that when these clauses are put together, and no disrespect to real estate agents, but it's important that the clauses get drawn carefully, and a lot of thought gets put into what the steps, what are we agreeing to, who has to do what, by when, and what happens if it's not done in accordance with the clause or by the date that it's supposed to have been done. So so it's really important that that those principles are filled, and that's what you've got to make sure that there's some skill, lots of skill, I should say, in drawing those clauses. So a lot of the times we see clauses that are supposed to be special conditions, but they're nothing less than a statement, and they don't really have much of an effect at all. So so it's important. But as in these uncertain times, people are reaching out for ways to do things differently and want to rely on COVID-19 as an excuse, if you like, to avoid a contract. But it's not that simple. So it's very important that you sign a contract. You need to understand that you have obligations. And if there's going to be special conditions, that those special conditions need to be understood carefully. The amount of times I hear, we've bought a property subject to finance, and if we change our mind, we'll just pull out under the finance clause. Well, it's not that simple if you want to read the finance, the relevant special conditions that relate to finance.
Let's talk about that. Let's talk about
obligations.
Because in our side of the town, it is a perception, with all due respect to a lot of the purchasers and their friends and advisors, or water cooler advisors, I should say, that subject to finance, if you don't get it, because we had one scenario recently where the purchaser put an offer in at subject to finance, and they got 4 extensions under the lockdown, and we did have an agreement in place anyways that if someone else comes along with a better offer with a better condition, being unconditional, we'll give you 24 hours to go unconditional as an opportunity. Otherwise, the vendor reserves the right to sell the property to someone else, which happened.
The
vendors exercised their rights. However, the purchaser was another extension, the 5th extension, mind you, asking, and also deposit wasn't paid. They were in default anyways. the decline letter came in, obviously that's another matter for the vendor to actually take the legal action against that letter because something was not right in that letter. However, it's not that easy because the vendor is not letting that purchaser go that easy either at the same time.
Mm-hmm.
And the perception is that subject to finance, our broker can write an email that will suffice. This is the perception, which sometimes the mortgage brokers as well give to their clients, being purchasers, that if you don't get to finance or if you want to get out, I'll just write you a letter on a letterhead or an email, which will help. What's your take on that? How that could be for the buyers?
So let's say the contract is just relying on the standard general condition that's contained in a standard contract. So we've had sort of two standard type contracts over the last, say, 12, 13 years where it was what we used to call the Estate Agents Act contract. And now there's a new standard contract that's come out under the REIV-LIV sort of partnership, if you like. And the general condition in both those contracts are extremely similar. That, you know, in the particulars of the sale, there's an ability to fill in the particulars of a loan arrangement or a loan condition, if you like. So, you know, an approval date, lender details, the amount of the loan, and what that means is that when you read across to the general condition, the purchaser is basically saying to the vendor, you know, I'll buy your property subject to me getting a loan of, you know, let's say $700,000 from the Commonwealth Bank and or similar lending institutions. Sometimes it can be described, you know, within 14 days from the date of the contract. So then you go across to the general condition. The general condition will say that the purchaser agrees to do all things reasonably required of them to, you know, apply for a loan, do all things immediately, that they'll apply for the amount that's been indicated in the contract.
Right.
And then the general condition goes on to say, well, under what circumstances can you end the contract? So, for example, obviously you'll need to have done all the things that were you agreed to do. And if you haven't received approval by the approval date, then you can end the contract. And general conditions generally give you 2 clear business days after the approval date within which to end the contract. But at the time that you end the contract, one of the things you must ensure is that you're not in breach of the contract at the time you serve the notice. So a lot of purchasers will say, I'll hold off paying my deposit until I've got the finance approved.
Yeah.
But in fact, they're in breach because in the contract, they actually promised to pay the deposit by a certain date, which is before the approval date, for example.
Right.
So when the purchaser seeks to end the contract, you know, either before the approval date or during the 2-day period,
right,
it's important that, you know, that as a purchaser, you ensure you're not in breach of contract. By not paying the deposit, you're in breach.
Exactly.
The newer version of the general condition actually requires evidence to be provided. Now, to your point, there's been commentary, you know, by some people from the legal fraternity that have given opinions in regards to what's considered evidence. And it's quite conceivable that a letter from a mortgage broker that attests to the fact that a loan application has been made for that amount simply either hasn't been approved because the bank just haven't got around to approving it because of delays.
Right.
Or they've simply indicated that the loan will not be approved, then it's quite arguable that that letter acts as evidence. So a broker, you know, when they're providing that letter, needs to understand that document's being relied on to end a contract. So I haven't seen too much in the way of too much argument over whether a letter from a broker is sufficient evidence or not, because the general condition simply says evidence. So it's just then it becomes an argument. If you want to have an argument over whether that evidence is sufficient or not, that's up to the practitioners involved. But so we generally see that with finance, particularly, over the last 12 months, maybe even a bit more, that most vendors are giving purchasers more time to get their finance approved, because we all know that it's taking longer and it's harder to get.
Right.
And most vendors are well versed in understanding that the purchaser is likely to be asking for an extension, so they need to be, ready for that. And you'll find that a lot of vendors that want to buy another property obviously aren't necessarily buying before they're selling, in the recent period, that, as I remember it, because there was a time where a vendor would go off and buy because they were so confident in what they were going to get for their place.
Exactly.
That it just didn't matter. They needed to secure their property that they wanted to buy first.
Exactly.
And there's so much confidence in the market that they were going to get, whatever price
or more,
or more than what they believed their property was worth. So it has, you know yourself better than me, but I can only read it from what I see, is that I get more vendors selling first and then buying, as opposed to buying first and then selling. Right.
I've seen a lot of license agreements for the vendors staying in the property for long as well.
There you go. Yeah. So they're settling, and then so the reverse is happening, where vendors are saying to their purchasers, look, settlement's due next week, for example, but I'm not due to settle my purchase, or I haven't found a place, any chance I can stay in and have a reverse license, if you like, because normally, license agreements are granted to purchasers before settlement so they can move in. But these are vendors wanting to stay in their properties beyond settlement. So, or they just simply agree to delay the settlement, if you like. But
or some vendors are trying to bring the settlements forward as well.
Yeah. So there's lots of different scenarios. We're going through, when we look not just at how the pandemic has affected how property contracts and transactions are happening, but when you really look back at the difficulty in obtaining finance and, the credit squeeze that's gone on, you could almost argue that probably interrupted the market more than the pandemic. Kind of, you've almost got some certainty around, that what the rules are around, what agents can and can't do, that you're going to have less choice, that buyers are going to have to potentially compromise to buy a property during this period on the basis they buy sight unseen, or there's a little bit more, I think there's almost a little bit more certainty. But if you go back before the pandemic and you think about the credit squeeze, and for me, that kind of created more uncertainty. The amount of times you'd get people, vendors selling their property, worried is the purchaser actually going to be able to settle, particularly when they sold on an unconditional basis or out of an option. So we get to have these conversations with clients that, that rather, they may not want to talk about them publicly, but internally they sign a contract, even if the deposit's been paid, it's still not enough comfort for them to be assured that settlement's going to happen. Are they going to be able to get a loan themselves? So we've probably been in uncertain times in that regard for a while, but notwithstanding the property market, in Victoria, because that's where my experience lies. The amount of activity still is high. It has remained high, and even notwithstanding the pandemic, it's still been relatively high. I mean, our pipeline of settlements, and even new matters that are coming on board and that are, settling quicker than normal. So the wheels are still churning.
How are the banks taking it? Like with the signing of the documents and also the settlement times and
look, I'm not really that I don't tend to criticise the banks as much as others do. My view is that the banks have been doing a pretty good job at getting loans. Sure, they've got tougher guidelines. They're making it tougher for the brokers and the like. But eventually, if the deal stacks up, it gets approved, and then once it's approved, the documents seem to get issued like within days.
Right.
And this PEXA platform has given the banks a little bit of freedom to juggle around and make things a little bit last minute. But we've almost become accustomed to it, and we don't panic if it doesn't appear the bank's ready, because come hell or high water on settlement day, that more often than not, they're ready. The matters are settling. I see the PEXA notification, coming through as soon as settlements occur, and those PEXA notifications are going to guys like yourself as agents that this matter's settled now.
Right.
So for me, I haven't seen a lot of I haven't seen a real slowdown in that space. I see things going smoothly. Granted that a lot of my team members that are involved more intrinsically in the settlement process, might look at me and say, well, you don't get to put up with the anxiety of, waiting for the bank to confirm they're ready to go and so forth. But again, I just look at the end result, and the end result is that they are settling on the date they're due to settle. And if they're not lagging that far behind. I know that banks are issuing mortgage documents and are accepting those documents as scanned copies going back to them, with certain notations being put on emails to confirm that due to the COVID scenario that it's unsafe for them to be delivering documents, but by sending them with the notation on the emails that this is the format I'm sending them to, and I will deliver once it's safe to do so. That banks are accepting those documents. Statutory declarations are able to be witnessed, for example, virtually, and there's laws in place that enable a person qualified to witness a stat dec to watch a person sign the stat dec, receive it, scanned, print it, sign it with the correct notations under their signatures, to confirm and attest that that's how it was witnessed. So there's mechanisms in place that have enabled transactions to settle and to proceed.
Different times, different ways, isn't it?
Exactly. PEXA couldn't have come at a better time. The State Revenue Office have, they've digitised. So, we do, I'd say 99% of our transactions with the State Revenue Office online. And even when you have to look at submitting documentation for special cases that need special assessments to be done, you can load documents onto the system and confirm that you hold the originals or whatever, and so it goes on. So I think the system's really working well. We're very fortunate in Victoria that we're one of the first ones to mandate the electronic settlement process. And I'm satisfied that it's working really well. So
I guess we had this thing, we've noticed this thing as well. We get an email from the vendor's conveyancer or the purchaser's conveyancer. We got CC'd in that we might have to delay the settlement for a couple of days. Banks are not ready. That was at 11 o'clock, and 4 o'clock we get an email, the property settled.
Yep, I've seen that before. Yep, where it's early in the day, you think it's not going to settle, and then somebody, excuse the expression, pull their finger out and the matter's settled. So don't forget, just like my clients are my customers, so to speak. The banks have got customers that they need to satisfy, and and they need to. They're accountable. Otherwise, their customers, so to speak, will leave and refinance with other banks if they're not.
Absolutely.
Yeah. So that's right.
And what would you advise, before we wrap up today's informative session, to the vendors, how to make things watertight in this current environment, so their deal is more secure and they've got this peace of mind that even if it's sight unseen? What are the two main tips you would give to the vendor?
Number one, don't cut corners with who you appoint to act for you, and ensure that don't get caught up in worrying about whether the quote you're getting is plus disbursements. What do the disbursements mean? You've got the right to inquire as to what makes up the disbursements. And what I mean by disbursements, they're the costs of getting the certificates. Understand that the certificates being attached to your Section 32 statement give a purchaser all the information that they should be receiving.
Yes.
And it also, the good thing about doing that is that sometimes these certificates can produce some information that the vendor wasn't even aware of.
Exactly.
Which then gives them an opportunity to repair a potential, a problem, if you like,
beforehand,
and then and then have the property, have the certificate reissued, and so you need to make sure that your disclosure statement is fulfilling of all the obligations.
Otherwise,
otherwise you leave yourself open. For example, if you've done building works, and this is probably I don't want to open up a Pandora's box for us to continue for another hour, but if you hear the term owner builder work, and you've legitimately done works that are actually owner built, then don't put your head in the sand in regards to the obligations of an owner builder, because if you fail to fulfill the owner builder obligations, then there's a real potential for the purchaser to avoid that contract just on the basis that you haven't fulfilled the owner builder obligation.
So get good, isn't it?
Yeah, that's right. Right up to the day settled, right up to the moment, and there's penalties that come with it too. So all I'm saying, I suppose you're asking me what to do to make sure, as best possible as a vendor, to secure yourself, a secure contract. Make sure that you're appointing someone that doesn't cut corners, that does the documents thoroughly, that you understand the terms that are being offered to you. So if an agent presents a contract that has a number of changes to the contract that you're not familiar with, that it looks like the document that was produced by your representative have been changed, then don't be rushed into signing it. Don't get overexcited. Go get the document, get it across to your representative, get them to explain to you. No disrespect again, Jazz, as an agent, but you're the vendor's agent. You're not the vendor's conveyancer or legal representative.
Exactly.
So I think it makes good sense that document be sent back to the practitioner to review and give the client the opportunity to get an explanation as to what those changes mean. They may be fine, but the vendor needs to be aware, because
peace of mind.
Because the biggest risk for a vendor is when they commit to a contract that could be avoided by a purchaser, and the vendor has committed themselves to another contract, because the two contracts are separate, and if they've purchased a property which they need to settle by a certain date, and they're relying on that sale to go through, then it could be disastrous, particularly if they're not in a position to raise bridging finance or other means to settle.
And that could open up issues for the agents or the agency as well.
Well, maybe, but obviously the advisors need to be well equipped and make sure that they've provided the right information and advice along the way. There's always some risk involved, but it's important to just stick to the course, get really good advice. As I say, don't penny pinch when it comes to, get good value for money. That's what I'm saying.
Absolutely.
Get the job done properly, and don't be fooled.
Especially now more than ever.
Yeah, competitive, just because there's so-called, all-in rates or competitive rates, just make sure you're getting, things done properly. Yeah. That'd be my...
And 100%. Now, thank you so much, Martin. Really appreciate your time. 2 weeks from now, we'll be talking a little bit more, guys, about how to buy a development site, or if you have a site where you've done subdivisions, pitfalls, and how to be more secure with Martin again. So we'll be back again with Martin in 2 weeks' time.
Thank you.
Perfect. Thank you so much for your time. And we'll leave Martin's details from Tickbox Conveyancing in the comment section. If you need to ask any questions, if you're on the market already, he's a great guy. Would love to answer your questions. Just reach out to him.
Thank you.
Perfect. Thank you so much, Martin. Really appreciate it.
We're done.